Welcome back. Now, the sixth Parliament will sit for the first time next week. Crime and corruption were among the topics addressed by most political parties going into the 2019 general elections. We took a look at some of the promises made by parties going into those elections and consider what the sixth Parliament will have to tackle first when it comes to crime and corruption. Now, to unpack the legislature regarding corruption, I'm joined in studio by Zaakir Mohamed, who's the Director at Corporate Investigations Sector of Cliff Decker Hofmeyr Dispute Resolution Practice. With him is Tami Nkosi, a campaign organizer for Right to Know. Thank you so much, gentlemen, for joining me this morning.
Good morning, and thank you for having us.
Now, Zaakir, I'll begin with you. I know that you wrote an article regarding what is the Prevention and Combating of Corrupt Activities Act. What does this entail?
So the Prevention and Combating of Corrupt Activities Act is South Africa's primary piece of anti-corruption legislation. If I may unpack this particular piece of legislation a little further, it's quite a comprehensive piece of legislation that addresses corruption in all its forms. Section 3 of, for short, I'll refer to it as PACA, Section 3 of this particular act contains a general offence of corruption. And it basically provides that if an individual gives, offers to give, or agrees to give what is termed gratification to another person as an inducement for that person to act in an unlawful manner or in a manner that amounts to a bias or an abuse of a position of authority, that amounts to an act of corruption. Now, I use the term gratification. Now, most of us, when we think of corruption or we think of bribes, we always assume it's money or some financial reward or incentive. But in our act, the term gratification extends to a lot more than that. It includes a gift. It could be a loan, an offer of employment. It could be any favor or anything or reward or gift to someone to do something that they're not supposed to be doing. So that's the general offense of corruption. And then our act goes even further. There's approximately just over 20 sections that contain specific acts of corruption, and those would be acts involving members of the judicial authority, gambling or games of chance. It could be corruption relating to agents, members of the legislative authority, etc. Then our act is quite unique in that it's got specific unique provisions. One of them is Section 28, which contains a register for tender defaulters, which is quite a nice provision that we have in our act. And basically, in terms of this provision, if an individual or entity has been found guilty of corruption involving tenders or contracts or the withdrawal of tenders, the court can order for these individual or entities' names to be placed onto this register. This register can be found on the National Treasury's website at treasury.gov.za, and basically it's available for the public to see. Now, if a person's name has been endorsed on this particular register, they cannot do any business with the government or state for a period of, I think it's about between 10 or 20 years. So that's quite a nice provision to have. And another unique provision that we've got in our legislation, which is quite a wonderful provision, is the positive obligation or duty to report. And that is contained in Section 34 of our Corruption Act. And basically what this means is that if a person in a position of authority who knows, ought reasonably to have known, or suspected that an offence of corruption, theft, fraud, forgery, uttering a forged document or extortion involving an amount of 100,000 rand or more must report that suspicion or knowledge to the Directorate of Priority Crime Investigation of the South African Police Service. We commonly know this as the Hawks. Now, I use the term person in a position of authority. Now, those persons could be the Director General or head of a government department. It could be the director of a company, the CEO of a company, the principal of a tertiary institution, a member of a close corporation, a partner in a partnership. And failure to report in terms of this particular section is a criminal offence, and it carries with it the penalty of a fine or imprisonment of up to 10 years. So that's quite a highlight of our key piece of anti-corruption legislation, but that's complemented by other pieces of legislation as well. We've got the Financial Intelligence Centre Act, which is our key piece of anti-money laundering legislation. We've got our Protected Disclosures Act, which is our key piece of whistleblowing legislation. Surprisingly, in our Companies Act, in Regulation 43, there's certain requirements that certain entities need to comply with in terms of implementing an anti-corruption and compliance program. And then the last piece of legislation that forms part of the suite is the Prevention of Organised Crime Act. And this particular act deals with anti-money laundering as well. It deals with criminal gang activities. It also prohibits organized crime activity, as well as the forfeiture of the proceeds of unlawful activity.
I'm just going to go back to something that you mentioned about the Act, saying that certain people holding positions of authority need to report whether or not they know about certain corrupt activities.
Yes.
I mean, does that also include family members? And I think I'll give this to you, Tammy. We saw with VBS, Julius Malima's brother, is said to have benefited from the looting there. We've got Bosasa and President Cyril Ramaphosa's son. Will they ever be held accountable for having knowledge of, the corruption that took place there?
We at least hope so. I mean, I think you would expect to have people in position of power to at least have some moral, responsibility or some ethical responsibility to ensure that they blow the whistle on any other corrupt activity that happens. But we also know that in the game of politics, sometimes, politics takes precedence over what is right or the moral aspirations of the society at large. And we see that with all the scandals that you had just mentioned. And I'm just hoping, that finally our law enforcement agencies would come to the party and people will be held liable, because I think the biggest conversation we're not having as a country is just the effect, or at least the cost to human life that corruption has. I think we've always been talking about, well, this money was siphoned this way, that way, Ramaphosa this, Ramaphosa that, and whoever, but we're not talking about the human cost. And until we have a conversation about the human cost of corruption, I think we're missing the point to some degree. As a civil society organization, for us, is to actually let suffering speak, to put the face to corruption, to simply say, Michael Komape that dies in a pit toilet shouldn't have died. Under those circumstances, if money from the public purse was used correctly, we shouldn't have mud schools in the Eastern Cape to this day and age. We shouldn't have a life as a Dimeni, we shouldn't have a Marikana if people were essentially doing what they're supposed to be doing. So for us, I think there's just too much information that is there in the public knowledge now. And I think the government can't turn a blind eye, whether they want to play a politics, whether they want to protect each other, but I think there's just too much that is out there that I think they're forced to act. So we're really hoping they would act finally, and would see some people, getting held responsible. But, well, you wonder when you see people like Boba Tabile Dlamini still going to Parliament. But that's another story for another day.
Well, I want to discuss, this issue further. But let's stop now for a quick ad break. We'll be back with this discussion when we return. Stay with us. Welcome back. Let's continue with our discussion now. Now, Zaakir, before I stopped you there, we were just discussing this act, and I hear that it covers so much. But why are we seeing such little convictions coming out of that? Why are we seeing, people not accounting for the corrupt activities that they are involved in?
I think that's a very good question that you've raised, and I always say that when it comes to South Africa, we've got world-class pieces of legislation, but one of the difficulties that we've had traditionally has been the practical implementation of that legislation. Because if you compare our Corruption Act to pieces of legislation globally, for example, our act is quite broad in its ambit. It really was drafted to encapsulate as many offences of corrupt activity as possible. And it does raise the question that you've just asked me now. For example, if you look at our register for tender defaulters. When I last looked at the register, I think it was a few weeks ago, there's no names of individuals or entities listed on that, and that register has been around for a sufficient amount of time, and it does beg the question. But I think if you're looking at what's going on in the last, I would say 2 or 3 years, certainly what's been reported on in the media, etc., I think the tide is starting to change, where there's a lot of attention being paid to these kinds of offences and trying to do something to stamp these kinds of offences out. And if you look at, for example, if you look at President Cyril Ramaphosa, he's initiated the new investigations directorate to investigate specific offences of theft, corruption, and all of these common law offences. And recently, I believe he's appointed Hermione Cronje to head up that particular division. So certainly it seems as though steps are being taken within our criminal authorities to start beefing up their capacity to investigate these kinds of offences.
Yeah. Tami, National Assembly first sitting on Tuesday. What needs to be prioritised?
Sure, there's a lot. I think we need to accept the fact that we're a society at all levels. We're a society that's at a crossroad, and I think one can specifically say there are particular priorities, but I think socially we're in trouble. And I think one of the key things that needs to be done with the sitting of the National Assembly is essentially ensuring that everybody that's been fingered, everybody that's been mentioned in any cases regarding graft, corruption, and all sorts of things, those are actually prosecuted and held criminally liable. I think that's the first message that the Parliament should send, to simply say we are not going to, in fact, tolerate anybody that steals from the public purse, and I think that would be a very strong message that would be sent out there. Secondly, it would be to strengthen and ensure the full functionality of oversight bodies, for example, like your Inspector General, your Public Protector, and any other such institutions, primarily because I think we've seen over the years that they've been politically infiltrated, and as a result, we need to refocus those and essentially bring back the public confidence into these institutions, and I think that's the critical thing that we need to do. And then thirdly, I think we need to at least try and build a social contract that simply says this is how we're going to move as a country, in the next 5 years, in the next 2 years, in the next 3 years. This is how we're going to address, the social collapse of the country. This is how we're going to address, service delivery issues. This is how we're going to address issues of corruption and graft and maladministration. So I think the critical thing is to essentially bring the confidence of the public back into the Parliament, bring the confidence of the public back into the institutions that are meant to actually protect and play oversight to ensure that the public is protected.
I'm going to have to stop you right there. We need to go pay our bills. Thank you so much for joining me. Do stay tuned for more news when we return.
Fill up your trolley with a